We kick things off with a probable cause conference. Think of this as a legal checkpoint. Is there enough evidence for the case to move forward, or does it stall here? Spoiler: these hearings often decide the road ahead before a jury ever hears a word.
Ellen Michaels on behalf of James Worthington. My P number is 67943. Mr. Worthington is present in court.
All right. Your name, sir?
James Worthington.
All right. Very good. All right.
So today's the date time set for our second probable cause conference. We had adjourned it in order to get all the Child Advocacy Center videos. I'm short 2 videos, though I've been notified that they have been sent to me. So I believe we're ready to set it for exam, assuming that they, in fact, were uploaded today as stated by the prosecutor. Clarification from confirmation from the officer in charge that they have just been available on evidence.com. I've relayed that information to the proper individual in our office. I would expect that those will still be shared with counsel before the day is over. So just be prepared for that.
All right. And if those are done, then the discovery is complete.
Yes.
They'll let you do it this way, but I get what you're saying. See that.
Understood, John. If there is a problem, I will bring it to the court's attention and file the appropriate stipulated motion in order.
Right. But that's what we try to give people time at PCC to get all that stuff straight and not set something and have it adjourn out. So
Understood.
I want to make sure that we're going to be able to go forward. People had their witnesses available the
28th of
January.
what time?
9 a.m.
Oh, I'm not available at all that day. I have a 9 a.m. exam and a 12:30 sentence.
February 4th
Checking.
or February 11th.
What time? February 4th, 9 a.m.
They're all at 9 a.m.
February 11th. February 11th is good.
Preliminary examination in person, February 11th, 2025, 9 a.m. before Judge Valvo.
I didn't hear the name. What name?
Valvo.
Thank you.
Bond will continue.
I'm asking Your Honor to again revisit the bond conditions. What I'm simply asking is that my client be reunited with his children. He does not need to go back to the residence that's across the street from where the complainant lives. Family can stay with a friend in a separate location, but since the incident that the 2 children of my client have been taken away, even though CPS has not filed any the case has been closed. There's no issues. Children are staying with grandparents, and this is going on since early December. People continue.
And here comes the big bond debate. The defense wants the father reunited with his kids, but prosecutors say those very kids might also be victims. That's a nightmare legal clash. Family rights versus child safety. If you were the judge, would you gamble with children's well-being?
Yeah, she's that right. Again, as I indicated the last few statement last day, I'm not comfortable agreeing to that because although I understand that defendant's daughter was interviewed at the CAC and did not disclose, that being said, our charged victim, her first trial best friend, in her CAC interview, where she made all of her disclosures, she indicated that his daughter also told her that she had been sexually assaulted, both by defendant and by their son. So I am concerned. I'm not really able to read the change response. Understand obviously also creates some concern for the safety of minor child.
And quite frankly, counsel, I'm in the same position I was last time, I think. I don't think anything's changed, and I denied the request the last time, and I don't have any additional information that would lead me in that other direction. So I'm going to decline. I'm not going to change its mind.
Can I just make a record on one matter? Sure. Thank you so much. My client's daughter, Lila, the prosecutor was talking about, she was taken by the police to University of Michigan Hospital and physically examined. There is no indication of any sexual assault. She was also, as stated, interviewed in a forensic setting and did not make any disclosures. We believe this is all part of these are all false allegations, and the children, there's no evidence that his children have been assaulted in any way. This is part of the discovery that was tendered to me by the prosecutor, the medical records and her interview.
As I indicated last time, same records need the same arguments need still important as as long as I have previous, there aren't hardly ever medical findings when a small child has been sexually assaulted. It's all about timing. It's all about sexual assault. It's all about those areas of our bodies being past healing. It's all about so many moving parts that a lack of medical information means zero things in terms of whether or not a child is possession.
Listen closely. Defense points to no medical proof. Sounds persuasive, right? But here's the twist. Most child assault cases don't leave physical evidence. Courts know this, and testimony often outweighs test results. Lack of medical records doesn't equal innocence. It just raises the stakes on credibility.
One more thing, Judge, that the allegations are that the daughter allegedly said that my client penetrated her every single day. There would certainly be medical evidence of that. Thank you.
Not necessarily be penetration, can be a whole lot of things with a whole lot.
And again, I know you read your record. I'm still at this point going to decide Judge Valvo after what happens to me differently before. This time I'm going to give on the request. God will continue.
Thank you very much.
Thank you.
Thank you.
That was the case of people versus Christopher Jordan. Yes.
Who's not present?
Who's not?
Switching gears, new defendant, new drama. Christopher Jordan is a no-show. His lawyer paints a picture of a man battling homelessness and clinging to treatment. But in court, excuses collide with procedure, and missing a hearing is a cardinal sin.
I was wondering maybe we could do this without him.
Yeah, for long you can. Violation.
Some of them supposed to be processing the no tax over. And some counsel and kind of provide correspondence from therapeutic stage yesterday. Reading the how issues, other things for therapeutics. But as I looked at that paperwork, I wasn't able to see a record. I'm not sure if I missed something. It's certainly possible, but I didn't see that corresponds actually there.
It's sorry, it's on the top of
I didn't see.
the second page. Clients in phase one who provide
Yeah, that's right. I think there would be some testing component to it, but I don't know where. Where are the results of those tests?
I don't have the results of the test. Therapeutics, Anderson is doing the testing, continuing to provide Mr. Jordan with the methadone that he is part of his treatment.
Okay, but are they sending the test to our community corrections?
Unfortunately, it seems they are not. So I don't have the results, but I do have record that Mr. Jordan is in treatment. He is living homeless, as I was explaining to opposing counsel, he avails himself of a lot of resources here. There are two volunteer social workers from the Warming Center that have actually been asked me to step into the case. I'm on this case pro bono. So Mr. Jordan is in treatment, and I apologize to the court that I don't have the record of the drug that's a result of the drug testing, but he's availing himself of treatment. He's attending these meetings, both individual counseling sessions and group meetings. And the other thing that I think is relevant to the court is Mr. Jordan, this is a case from 2022, 2.5 years ago. There's a more recent case he was charged with a misdemeanor, and we resolved that last year with the prosecutor's office dismissing the case pursuant to Mr. Jordan being in treatment, which is still in treatment. And so it just does feel a little counterintuitive that this is a more recent case for Mr. Jordan's compliance with treatment, which he's remaining in compliance with. And we've now charged him on a felony from 2.5 years ago. I'd ask the court.
So you should say the prosecutor should not do that kind of thing. I mean, if they've got to be intuitive, that everybody should charge and just go for it. Never mind. Go ahead.
I'm asking the court because this case also involves an extremely questionable stop by the police in search of Mr. Jordan. He's walking down the street or jogging down the street. I'm asking the court before a warrant is issued on such an old case where there was a questionable, there's, I argue, a Fourth Amendment violation.
Okay, I get that. If he got here, then we could have the hearing on all of it.
Yes.
But he's not here.
I understand. He's ill. He's living homeless. It's extremely cold outside. He's managed to continue to get himself into treatment. So, just asking that the court hold off on a warrant and allow us to litigate the legitimacy of this arrest without a warrant issuing.
Well, I'm going to issue a bench warrant for failure to appear at this proceeding. And, I mean, I might not do that if I had test results coming in. But I really, none of this really puts a picture together for me of where.
Boom! Bench warrant issued. That's the legal hammer. Skip court, and suddenly police are hunting you down. Bond skyrockets, and your credibility tanks. Freedom here is literally measured in dollars. $25,000 cash, to be exact.
I'm sure what he's doing. And certainly not testing. So, when issue bench warrant, bond will be sent about $25,000 in the security. Located and can get him in with a warrant recall procedure. That warrant will issue. Thank you. What are you doing? Another. Oh, because I finished. Calls the case People versus Tornier 2440331.
Good afternoon, Your Honor. Charlotte, on behalf of Mr. Cornier.
Oh, okay. Mr. Tornier. All right. So what we've done, this is on the case that is before Judge Fresh out. I'm going to recall the bench warrant. We spoke with Judge Fresh out. I will reset his hearing to January 30th, 2025 at 9 a.m. for Judge Fresh Hour. I'm setting aside the warrant, but he must test when community corrections he needs. Probably good with it today. Well, maybe he'll still be in. I think it's close to 4:30. Okay. So I'll come back another day. I'll do it tomorrow. But we got your warrant signed. Question is what I also did is we checked with Judge Frazier. The oral testing is also appropriate for sufficient in this case, so don't be all.
Thank you.
Yes, sir.
Is there cost? The mouthful.
There will be a cost.
I just need to know how much so I can figure it out.
By the way, do you know how much the oral testing is? Anybody? Oral testing at university?
Yeah, someone, I think.
Yeah, it's more expensive than the all right. Here's what you do. Get yourself done. You got to do that within 24 hours. Okay? So get that money together. Get down here tomorrow if you can and get the test. Okay? And get the first one and try to work this time to do each one. Okay? All right. Make sure to get that one in so it doesn't look like it's full. It's $20. Okay? Thank you. You're welcome, sir.
Thank you, Judge.
You're welcome. Court does call the case. Cases of the people versus Allen Maloney. On these cases, Mr. Sugar got here. Mr. Sugar did contact our office.
Yes, sir. He contacted me as well. I know we're having difficulties with that.
Yes.
I told him that would not be concerned with the string. I would request a new data for the half. That will understand the client is not.
Yes. So, I don't know how long. All right, let me adjourn that a couple weeks. Okay. So, probable cause conference January 30th, 2025. And you again busy and ready. John will take. Okay, please, yeah.
Now contrast that with Torres' case. His warrant gets recalled. Why? Because he actually communicated through chambers. Courts punish silence but reward cooperation. The justice system showing both its stick and its carrot.